everyone. My name is Nurhazika binti Mamazrin. My matrix number is 066119. I will represent my group from group 6 to answer the question 3 from the case study.
So this is our group member.
I am the first presenter and also my friend the second presenter. So I will be answering question 3A. Question 3A. Hafiz wished to purchase a new washing machine and dryer machine. However, he does not have enough funds. He comes to seek your advice as to how a valid hire purchase agreement is formed. Briefly describe the formalities required for the formation of a hire purchase agreement in accordance with the Hire Purchase Act 1967.
So the introduction
To
is
buy goods for people who cannot afford them, a hire purchase agreement can be established in accordance with the Hire Purchase Act 1967. The agreement must comply with the conditions set by the Act for it to be valid and effective. The proposal should specify the formalities required for the formation of the hire purchase agreement. So, from the issues, Section 1 2. First, schedule a hire purchase agreement in Hafiz issue. The washing machine and dryer he wants to buy will list under consumer goods, so that the hire purchase agreement will apply. Section 2 1. Of the Hire Purchase Agreement 1967. First, it covered the leasing of goods with the option to purchase. Second, it also covered the agreement for the purchase of goods in installment. Secondly, third parties involved the agreement. First, the seller who acts as the owner. Second is Hafiz who acts as the tenant. The third is the one who acts as a trader. Next, Section 4 1. Delivery of second schedule notice. The agreement must be communicated before the formation of the agreement during negotiation. The agreement has to be completed before it can be awarded service to the prospective tenant. 2. It has two parts, namely, Part 1, it will be given by the owner if the negotiation is done by the owner or agent. Part 2, state that it will be given by the dealer if the negotiation is conducted by the dealer. In Hafiz's situation, Part 1 is most appropriate. The hire purchase agreement must be in writing and in the national language or English language. If it does not comply with the requirements, the agreement is avoided. The agreement must be signed by or on behalf of the all party to the agreement, and it must be completed before the hire signing. An owner cannot deliver any form or document relating to a hire purchase agreement that has not been duly completed. If the agreement is not complete or signed, it is avoided, and the owner or dealer is guilty of an offense. Next, the hire purchase agreement must contain specific details, including the data of commencement of hiring, particular of goods, payment of installment, financial obligation, and where the goods are kept. If the agreement does not contain this particular, it is avoided, and the owner or dealer is guilty of an offense. A separate agreement must be made for each item of goods, or the agreement is void. If an owner does not comply with this requirement, they are guilty of an offense. Next issue of it is Section 5.1 Hire and Purchase. The owner shall serve the copy of the agreement within 21 days after the making of a hire purchase agreement. Section 5.2 At any time before the final payment has been made under a hire purchase agreement, the owner should, within 21 days after he has received a request in writing from the hirer, supply to the hirer of any memorandum or note of the agreement on payment by the hirer of the prescribed fee. Section 5.3 of Hire and Purchase. The owner shall serve a cost to be served on the hirer with a copy of the insurance payment receipt. Within 7 days of receipt of the policy, a copy of policy or statement in writing setting out the terms, conditions, and exclusive of the policy that affect the right of the hire. So, in conclusion, Hafiz can create a legal hire purchase agreement for the purchase of a new washing machine and dryer by following the processes and specification outlined in the Hire Purchase Act of 1967. By doing so, Hafiz can ensure that the hire purchase arrangement is legitimate and functional, enabling him to purchase the equipment he wants while successfully managing his finances. Thank you. That's all from me.
Assalamualaikum warahmatullahi wabarakatuh. My name is Cica Nufia binti Muhlisi. I will present the situation for 3B. The situation given is, one day, Udin bought nasi lemak from restoran Nenek Kebayan. After eating the food, he was hospitalized for food poisoning. Advised Udin as to his right under Sale of Goods Act 1957. Alright, first is the introduction. Consumers are often concerned about food safety, and when unpleasant events like food poisoning happen, it's crucial to know what legal rights and protection are available for them. Examining the pertinent section of the Sale of Goods Act 1957 is crucial in the case of Udin, who recently became ill after eating nasi lemak from the restaurant Nenek Kebayan. This law lay four important rights and restrictions that apply to consumer transaction, giving people like Udin possible channels for recruiting redress and compensation. The issue from this situation is Udin was hospitalized due to food poisoning after he ate at restaurant Nenek Kebayan. Does he have right to get compensation for the first case of nasi lemak? This case is in according to Sale of Goods Act 1957 SOGA. Next is the law. The meaning of the Sale of Goods Act 1957 has been stated in Section 4, Subsection 1, a contract of sale of goods where the seller transfer or agrees to transfer the property in the goods to the buyer for a price. If there is a sale agreement between two parties, including the goods mentioned above, the agreement will be governed by SOGA in addition to standard contract law principles. Also, stated in Section 16, Subsection 1, Clause B of the Sale of Goods Act 1957, applied the condition that the goods should be of purchasable quality. This means that when the product are purchased by description from a seller who deals in goods of that description, whether or not he is the manufacturer or producer, there is an implied requirement that the commodities be of purchasable quality. Even if the items are sold under the seller patent or trade name, the seller would be held accountable for breach of applied condition if the goods were unpurchasable. Section 12 provides that a stipulation in a contract of sale with reference to goods in question can either be a condition or warranty, and Section 12 Subsection 2 defines condition as a stimulation essential to the main purpose of the contract, and any breach of that condition entitles the innocent party a right to repudiate the contract. This is because the buyer have the right. Among them are to reject the product, cancel the agreement, and make a damage claim. Next is the application of the law. Udin has bought nasi lemak from restoran Nenek Kebayan. That turns it into a contract of sale of goods where the seller transfer or agrees to transfer property in of good to the buyer for a price. Accordingly, Udin has the right to sue the restaurant because it is possible that the food in the restaurant was exposed to to the point of affecting the food served there, which has put Udin at risk of food poisoning. Besides that, Udin also can make a claim for compensation from the restaurant Nenek Kebayan because the food sold was caused Udin to suffer from food poisoning. This has been stated in Section 12, Subsection 2 that a condition is a stipulation essential to the main purpose of the contract, the breast of a which give rise to a right to treat the contract as repudiated. This is because the buyer has the right to reject the product, cancel the agreement, or make a damage claim. Next, Udin can also make a claim for treatment costs because he was treated to hospital due to food poisoning. Udin also need to inform hospital about the food he ate which caused he to get food poisoning for further action. In conclusion, the Sale of Goods Act of 1957 (SOGA) applies to Udin case of food illness brought on by eating nasi lemak from restaurant Nenek Kebayan. Due to possible violation of the applied condition of merchantable quality, Udin has the right to demand payment from the restaurant as well as legal action. Udin claim is supported by the precedent established by the Bartley v. Marshall case, as he might have relied on the restaurant assurance that the meal was safe for indigestion. Udin has the right to refuse the product, revoke the contract, and seek compensation under Section 12 of the SOGA. He might also ask for reimbursement for his medical costs by offering pertinent details that will help in identifying the sources of the poisoning. Udin has a solid case for getting compensation and holding restaurant Nenek Kebayan responsible for the harm caused in light of those legal guidelines and precedents. The Sale of Item Act in 1957 provides an essential framework for safeguarding consumers' rights and upholding seller obligation to deliver items of a sufficient caliber. That's all from me. Thank you.